Connolly, you're first.
And I welcome the opportunity to speak on this, and I welcome the Minister's apology for what has happened. However, the Minister must do more than apologise and give empathy and sympathy. And if he looks at the judgment from the International Covenant on Civil and Political Rights, there was a duty on him to publish this and make it available. He might confirm whether he did that. He also has 180 days to make information available about the measures taken to give effect to the committee's views. And he must show what effective remedy the state is going to provide. So he's under an obligation, legal, to come up with a solution in relation to this matter. And perhaps I might take the government's view more seriously if they had come forward themselves in relation to their obligations in view of this decision and told us what they were going to do. I might take their advice more seriously that this draft legislation is unconstitutional. But I do welcome the tone of the discussion tonight. I do welcome the rational and reasonable debate. And if we look at the Minister might come back in relation to his obligations. If we look then at 1983, when the famous amendment was brought in 1983, that was the year when the Bishop of Galway was Dr. Eamon Casey. That was the year when the Magdalene Laundry in Galway was still open in 1983. And that was the year when Sheila Rogers died in Drogheda, a young married Dundalk mother of two who died in Our Lady's Lourdes Hospital in Drogheda, having given birth to a premature baby. She had become pregnant while receiving treatment for a recurrent cancer. The hospital had refused to allow her to stay on the treatment because of her pregnancy. She died. Cancer returned. She died. Her baby died. That was 1983 when we brought in the amendment to the Constitution, when many lawyers and academics warned that there would be great difficulty in putting in this amendment to the Constitution in 1983. And of course the problems emerged. In 1992 we had the X case, and we had the treatment of a 14-year-old girl who was violated, became pregnant, going off to England for an abortion, and the High Court sought A, to do everything in secret, B, to prevent her going, and we had the DPP and the Attorney General trying to prevent a 14-year-old. There isn't a single mother or father in this chamber that would have not taken their 14-year-old out of the country to seek a termination. And thankfully the Supreme Court acted very sensibly at the time and made a judgment. And they deplored the fact that no legislation had been brought in, and they allowed Miss X to travel, and she deserves her privacy. And I'm simply talking about the principles in relation to this. And they deplored the failure by successive governments to pass legislation. The failure by the legislator to enact the appropriate legislation is no longer just unfortunate, it is inexcusable. That was 1992. The then President Mary Robinson issued a statement on the very deep crisis within ourselves. I hope we have the courage, which we had not always had, to face up and to look squarely and to say this is a problem we have to resolve. What happened? 1992, there was another push for an amendment to copper fasten the amendment of 43.3 and to rule out suicide as a ground. Fortunately, it was rejected by the people. And further, in 2002, a further referendum to overturn the X case, not to deal with the problem, not to bring in appropriate legislation. Unfortunately, it was again rejected by the people. And then we go forward to 2010, and because of the failure of successive governments to bring in appropriate legislation, we had the A, B and C case, the International Court of Human Rights, and they found that Ireland had breached the human rights of a woman with cancer who had to travel abroad to get an abortion. In that case, the woman C had a rare form of cancer and feared that it would relapse when she became unintentionally pregnant. However, the woman said she was unable to find a doctor willing to make a determination as to whether her life would be at risk if she continued. And that was a finding against us again, Minister, in 2010. You would imagine we would have learned something then, but it took another death, Miss Hart's death in 2011. And really, it is worth just taking a moment in relation to Miss Hart, who died in November 11. She suffered from malignant melanoma, forced to go to Britain for an abortion despite being terminally ill with cancer. The Hospital Ethics Committee Forum had decided against authorising an abortion, and on the basis that her life was not under immediate threat and so on. The doctors were willing to carry out a termination, but the Hospital Ethics Committee said no. She went on a plane. She had to be helped on a plane. Such was her illness to seek a termination. And so when she came back, her solicitor took a case and got a substantial award for her, and she died a few months later. She left a child behind her because we failed utterly to deal with the legislative situation. That was 2011 she died. And then to my own city, Galway, 2012, and we have the shocking case of Foetal Halappanavar. Her doctors, her nurses were acting under an unworkable regime of laws. Besides any other questions in relation to a lack of basic care and treatment and lack of resources in the hospital, there was certainly an issue in relation to a termination. And that forced the government to act, and that was the expert group's report, which was suddenly published, and that led 2013 to the Protection of Life During Pregnancy Act. And just to clarify what that act is doing, that will criminalise me if I'm beyond the age, but a woman of criminalise them and a long prison sentence or a fine or both if they seek to terminate, if they have a fetus that is a fatal fetal abnormality or for any other reason. That's what we have done with the 2013 Protection of Life During Pregnancy. I mean, it really is a cynical use of language to call that a protection of life. And here we are again then, 2016, and we're being forced to act again because of our obligations under the Covenant. And just in relation to that committee were at pains to point out, just because we have legislation like the 2013 Act, and just because we have a constitution amendment, that is absolutely no excuse. That is absolutely no excuse for not providing services for women who find themselves in this position. And in the case, as has been pointed out, of Amanda Jane Millett, they found that there was a violation of her rights under Article 7 and that her treatment amounted to cruel, inhuman and degrading treatment. Cruel, inhuman and degrading treatment. Can we stand over that? A violation of her rights to privacy under Article 17 and a violation of her rights to, she was discriminated under Article 26. As we speak, 11 people will leave Ireland today to go to have an abortion in England, many of them carrying a fetus that is a fatal abnormality. Can we stand over that system where 4,000 approximately per year that we know about leave our country? And that's just to England, and that's just the people that we know about. How could we stand over that in this dull chamber?
Your two colleagues who are trying to get in.
Sorry, I beg your pardon. I didn't realise I was sharing. I thought you were giving everyone time.
No,
I beg your time. I support this amendment. I support this bill. And just to point out, in 2015, 135 women left Ireland for Britain to terminate a pregnancy on the basis that they're fatal fetal abnormality.
Catherine Martin. Yeah.